And we'll move now to our second speaker. Our second speaker is Assaf Likhovski from Tel Aviv University, Faculty of Law. Professor Likhovski is a graduate of Tel Aviv University Law Faculty and the School of History and of Harvard Law School. Currently, he serves as the director of the Zegla Center for Interdisciplinary Research of the Law. His research interests include the intellectual history of law and the history of taxation. Professor Likhovski published articles on taxation, legal history, and sociology of law and comparative law, including a book on the legal history of British-ruled Palestine. Professor Likhovski is, as we heard, a leading scholar on Israeli legal history, and he is one of the founders of the Israeli Legal History Association. Professor Likhovski's talk deals with a long and intense debate in Israeli legal history, the relationship between Israeli law and Jewish law, or as it's called in Hebrew, Hebrew law, Mishpat Ivri. And on the one hand, Jewish law is an essential element, one may say the essential element of the Jewish legal heritage, one that a Jewish state must incorporate into its system. I may share you incident I had a few days ago when I participated in a workshop at the Columbia Law School in which Suzanne Stone presented a work of her on a Talmudic issue, and several faculty members have approached me before Suzanne's talk saying, well, as an Israeli law professor, you are obviously an expert in such issues. This is clearly not the case. In fact, most Israeli legal scholars and practitioners, as well as judges, know the American legal system much better than they know the Jewish law. Professor Likhovski's talk traces back the roots of this debate by addressing an unknown affair that took place shortly after the foundation of the State of Israel in 1948, which relates not only to the role of Jewish law of Mishpat Ivri in the Jewish state, but also to the content of what should be the content, the relevant content of this body of law. In his talk, Why Isn't Israeli Law Jewish? The Failed Legal Revolution of 1948. Assaf.
Okay, thank you. I should also say thank you to the organizers of this wonderful conference. And I thought that I'd start, like some of the speakers early this morning, like Stephen Flanders and David Wilkins, by saying that I'm also an outsider. I'm also, unlike most people here, not a Jewish lawyer. In my case, I'm an Israeli one. Okay, and Israeli and Jewish, as I'll try to show, are not the same. Actually, this is kind of a bigger question, which maybe we should have discussed more in this conference. What exactly is Jewish? Who is a Jew? And obviously there are different definitions of the term. It's a cultural, religious, ethnic term, also maybe related to food, as we learned this morning. Okay, and my talk, as Barak said, is about Israeli law and Jewish law and its relationship. The conference generally is about Jewish lawyers, and we can analyze this term, Jewish lawyers, in various ways. One way to do so, and some of the panelists today talked about it, is to look at Jewish lawyers and compare them to lawyers coming from other ethnic backgrounds, WASP lawyers or African American lawyers. But one can look at the term Jewish lawyers and try to analyze its two parts, Jewish and lawyer. What happens when there's a conflict between the two parts? One can think of a conflict between, say, the professional interests of lawyers on the one hand and a commitment to Jewish ethical values. And I'd like to analyze a second kind of conflict, one between the professional interests of lawyers and a commitment to Jewish culture, to nationalist ideology. What happens when lawyers are committed to the narrow professional interest of their specific professional group on the one hand, but also to, in my case, cultural Zionism, I want to look at Israel in 1948 and see what happened when Israeli lawyers were faced with this dilemma, with this problem. And 1948 is merely one example of a conflict that actually existed for most of the 20th century in Palestine and then in Israel. So my paper has 3 parts. I'll focus on the third and last part. The first part of the paper is basically an overview of the legal history of mandatory Palestine, talking a bit about the process in which the law of mandatory Palestine became was linked to English law. Then I talk in the paper about failed attempts to create a legal system based on Jewish law in mandatory Palestine and also in post-1948 Israel. And actually, Ruti Gabizon talked yesterday about 1980 and the Foundations of Law Act, but 1980 was only the last episode in something that began in the early 20th century, and I talk a bit about the history of the failed attempts to link Israeli and Jewish law. And then the paper asks what are the reasons that these attempts failed. And I talk about several reasons. First of all, I talk about practical reasons that prevented the linkage between Israeli and Jewish law. Then, because this is a conference about lawyers and the legal profession, I talk about professional lawyers and their opposition to Jewish law, some professional lawyers and their opposition to Jewish law. And then I ask, why did this opposition succeed? And I offer a cultural explanation. I talk about cultural images that lawyers shared with the wider Israeli population, and I argue that some lawyers successfully manipulated these images in order to prevent a linkage between Israeli law and maintain the linkage between Israeli and Western, mainly English law. And I focus on one specific cultural image, an image of Israeli society as what people call the desert generation, a society which is in a process of transition, which has not reached perfection yet, and therefore does not really need the perfect law, can live with a legal status quo which was based on English law. Okay, so the first part of the paper, as I said, is about the law of British-ruled Palestine. This is just a quick overview. In the 19th century, Palestine was part of the Ottoman Empire, and the law of the Ottoman Empire at the time was a mixture of Islamic norms and practices and courts, and also Western, mainly French, norms, courts, and practices. The British came to Palestine in 1917, and they ruled the country for 31 years. And in these 31 years, they anglicized the legal system, or partially anglicized the legal system, that is, imported English procedures, norms, practices into the law of Palestine. So basically, they changed the basic features of the legal system, importing an adversarial mode of litigation, a conception that judges have a major role to play in creating legal norms, a unitary court system, and many other basic features. They also imported a lot of English law, and so a lot of fields of the law of mandatory Palestine became anglicized. So criminal law, tax law, evidence, procedure, a lot of these areas there was legislation enacted based on English law, and they became English. The most important thing the English did, from my perspective, is that they changed the identity of the legal system. Ruti Gabizon mentioned this yesterday. In 1922, the British enacted the Constitution, something like a constitution of mandatory Palestine. It was the Palestine Order in Council of 1922, and Article 46 provision, or Section 46 of the Palestine Order in Council, said that when judges encounter new legal questions, when there are gaps in existing legislation, they should turn to the doctrines of common law and the principles of equity. So the identity of the legal system, the default rule became an English default rule. English law was supposed to fill in gaps in the legal system of mandatory Palestine. The British left in 1948. Israeli independence is 1948. And what they left was a legal system which was partly Ottoman, that is Islamic and French, and partly English. And Israelis, surprisingly enough, retained this legal system. It's still, in many senses, the legal system of Israel in 2006. This is why Barak doesn't know a lot about Jewish law, but knows more about English or American law. and me too, actually. We still, large parts of the mandatory legal inheritance are still in existence. So our tax code, for example, is still based on a British enactment from 1941. Our criminal law code is still, of course, with many changes, still based on a British code from 1936. And I can go on and on talking about specific areas of law. There was, as Ruti Gabizon said yesterday, there was a formal attempt to decouple Israeli and English law, but this didn't happen in 1948. It happened in 1980 with the Foundations of Law Act of 1980, which said that Article 46 is abolished.